for remote, so I'm gonna give it a minute, because we do a roll call vote. I'll just do an overview of the meeting real quick. Do a public comment, and then executive session, purpose 7, to review our minutes from June 4th. Then another executive session to discuss OML filed by John Lippert. And then we have executive session to discuss another OML from Dan Dewar. And then we have discussed rationale for potential select board reorganization. And last is executive session, discuss and potential vote to waive attorney-client privilege on a legal memo addressing the Killam School Building Committee, blah, 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 stuff, public records law. Melissa's not, all right, so I'm gonna do a roll call vote. Melissa?
Here.
Mark?
Here.
Chris?
Here.
Karen?
Here.
Carlo? Here. All right. I'm hoping you've all signed in. I'm gonna start with public comment. Can you raise your hands, how many are speaking? All right. So I'm gonna do 2 minutes, please, if you can do it under. If you're at 2 minutes, you'll hear my alarm and hopefully you can wrap it up. Ed, please.
Thanks, Carl. Good evening, everybody. Ed Ross, Kensington Ave, FinCom, Killam School Building Committee. On the 27th, this body voted to change the select board representation to the Killam project from Karen to Chris. And I'm not here to challenge the result. I can't because I don't have all the facts. And after watching your meeting, neither do any of you. Nothing happened in our meeting last night that required an urgent membership change. And frankly, it only introduced questions as to the validity of the business we did conduct. The public came to our meeting last night, first time ever, and asked a lot of questions, trying to understand the reasons and looking to us for answers. Multiple members, including myself, requested future agenda items to discuss our roles, our process, responsibilities, really because of this body's inability to handle the public business transparently. Now, I've had my frustrations on how slow town government moves sometimes, but I believe in this case, it's fair to ask, what was the rush? Now, Carlo, I thought it was admirable for you to ask about sharing information, but you can't have it both ways. Why not share and talk to Karen about the information prior to the meeting, similar to what Jackie did? Actioning a vote without enough information undermines that very vote. Only a summary of one letter and anecdotes of being late were reasons provided. That sets a dangerously low bar. Yet, you still voted. Lastly, my last point, Chris stated during the discussion that this wasn't new information to anybody. Now, I'm here to emphatically state that I didn't know all of the information, and I believe others on the community feel similarly. Also, Chris stated that we are jeopardizing the project and that Karen had become a liability. I'm wrapping it up, I swear. That does a massive disservice to the other 8 members of the committee, town leadership, school administration, the teachers, and other volunteers that have devoted countless hours. That doesn't even include the OPM and the designers that we've hired. We are far from jeopardizing the project. This project is meeting aggressive timelines and on budget. It continues to be a success and something the community should be proud of. Thank you.
Thank you, Ed. Is it anyone, saw Mary Ellen first?
Thank you. Mary Ellen O'Neill, 125 Summer Ave. I am deeply dismayed and discouraged by some of the recent actions of Select Board members Bocci, Haley, and Murphy. Respected members of committees have been ignored or discarded, and in the instance of CPDC, replaced with an individual who has a financial stake in the game and a significant uncompleted housing development right here in town. At an unusual early Thursday morning meeting, these 3 Select Board members voted to remove their colleague, Ms. Herrick, from her position on the Killam School Building Committee. Mr. Haley touted her accomplishments on that committee, but voted to oust her despite the breadth of her experience. Ms. Murphy stated that she was voting blindly, but proceeded to vote anyway. And Mr. Bocci waved a piece of paper in the air that contained a list of grievances which he had received, not from the school building committee, Killam School Building Committee, but just from the committee's chair, who had not consulted her committee before talking to Mr. Bocci. The Select Board has on its agenda this evening a discussion of the rationale for a reorganization of the board. Mr. Bocci made a huge stink a few months back about the Select Board needing to reorganize while it was at 4 members, declining to wait for the special election in May. He also made a big push, a successful one, to get himself elected chair. Ms. Herrick was elected vice chair. Now Mr. Bocci wants to carry on with his blatantly obvious personal vendetta against Ms. Herrick by initiating discussion of yet another board reorganization this evening in an effort to remove Ms. Herrick from her vice chair position. I respectfully ask the board to not move forward with this effort, but choose instead to put its time into improving its reputation and working on the critical tasks before us. Thank you.
Thank you. Nancy,
Go first. You want to go first? Yeah, and I'll go after.
okay,
Yes, good.
cooking's important.
Yes, eating is important. Yes, Kendra Cooper, Precinct 8, town meeting member. And following or trying to follow the open meeting law issues and all of these things that have been the confusion and misunderstandings that are happening, I'd like to suggest to the select board that they contact the Attorney General's office and have them come out and do a roadshow. Not like the town council, not like expecting everybody to go Zoom, because Zoom is, many people in this town, though I understand many of you don't realize this, people don't have computer access. There are many people who don't necessarily get the newspaper, and we try to get as much as possible in the newspaper about these meetings when they are. And if you notice the hybrid meetings or the Zoom meetings, when RCTV puts them on, unless you already know the people's voices, you don't know who they are. And sometimes, like, I ran into someone at CVS today who knew me, but I didn't know him. And he started talking about a meeting that he saw, but he didn't know what one it was. I mean, sometimes I'll see public health, and there are a lot of important issues that are on right now. So my suggestion is that you contact them. Years ago, I had them come out to do a roadshow, probably in the 1990s. Michael Furby was the assistant to DA's office. At that time, district attorneys did this. And they came out, and then RCTV videoed it, and then they played it over and over, sort of like graduations and things like that. And I think that it would be really helpful if you did. About 4 months ago, I wrote an email to the Attorney General's office asking them if they could come out and do a roadshow. And instead, I got this very formed email saying, they can go on Zoom, and you can't. There are people we're not reaching. If we have the same information that goes out, then people, the public, who are really the enforcers of the open meeting law, they're the ones that watch meetings and say, wait a minute, how did that come to pass? Because open meeting law is the ability to see and hear, the mechanics, the meeting, the discussion. And when you have new technology like we have now, it's very difficult. And I think it would be great to have a refresher course for the public, maybe at an open meeting that people could attend, or maybe people could call in, sort of almost like what happens with town meeting. But something like that, because I really think we need to have, like, not just a refresher course for people who are on boards, but people who watch, so they understand, and to be able to see who they are. In those little blocks on the right-hand side of the screen, nobody knows who that is. And I think you get much more support, especially with the Killen Project and the Senior Center Project. You got to reach the people who are affected.
Thank you.
And they're not. Anyway, okay, that's all I wanted. Now I've got to go home and cook.
Thank you.
And feed the cat. Thank you.
Thank you. Nancy Dr. Pearl Street. On June 18th, during your vast deliberations, you had a chance to do 3 things. Support nighttime government, defer to subject matter experts, and acknowledge and support the findings of the Community Health Initiative Survey, which highlighted the need to improve access to mental health and build resilience among our kids and young adults. Instead, the majority of this board, one, told every board, commission, and committee member that you really have no value for any of them in nighttime government. You told subject matter experts that you have disdain for them. And then you announced to the community that not only don't you really value public health, but you don't seem to really care about their mental health struggles or theirs of their kids. You had 2 candidates for 2 positions on the Board of Health. One was an LICSW with pediatric expertise. The other was, as this board categorized, a fish salesman. The chair and the vice chair of the Board of Health, a physician and a healthcare professional, citing the needs of the community, had requested the full voting status for the LICSW as a way of meeting the needs of the board and the community. Somehow or other, the majority of this board thought they knew better, and you did the exact opposite. The reason you gave was that the fish salesman had inspection experience. I looked at the resume that was online. I saw no evidence of education, certification, or experience for doing health or safety expectations. I have no issue with any volunteer submitting an application. I have an issue with this board. Actually, I have an issue with the majority of this board. Your reckless decisions are endangering our community, and you need to dig yourself out of the hole. And I would suggest you do that by returning the autonomy and the authority to the chairman of the Board of Health to determine the needs of his board and the community. Thank you.
Thank you.
Thank you, Carlo. Jeffrey Dietz, 10 Orchard Park Drive, Town Meeting Member, Precinct 5. Last Thursday morning's meeting, in which Ms. Karen Herrick was removed from a committee on the basis of a list of grievances that few people got a chance to look at and discuss. The whole thing reminded me of the novel The Trial by Franz Kafka. In this novel, a man is arrested, jailed, and tried for crimes that are never disclosed to him or the reader. During the course of the story, when the defendant asks, "What am I being tried for?" he is only told that he is only making it worse for himself by asking, and that everything will go much better for him if he just accepts his fate. The trial is an allegory about opaque and arbitrary power being exercised. And here we are anticipating another arbitrary exercise of power in the form of an imminent rework. I've lived in Reading for 30 years. I want to live in a town where the volunteers are given the opportunity to devote their expertise, time, skills, and energy improving the town for all residents, not just the ones that think, look, or swat a ball like them. Town government is intended to be nonpartisan, yet those who complain most loudly about divisiveness and transparency are now wielding their power in the most divisive, partisan, and opaque fashion. It's not fair, and it's not good for the town. Thank you.
Thank you. I think I saw Mr. Lippett.
Good evening. Thank you for this opportunity for public comment. I'm John Lippett from 23 Mineral Street, former longtime town meeting member from Precinct 7. I'd like to address the issue of transparency. I believe all of you have stated you're committed to transparency, but some of the recent conduct of the board and some of its members would seem to indicate otherwise. First, thank you for holding this meeting on a Tuesday evening. That's when select board meetings have been held for as long as I can remember. Having a regular meeting time in the evening facilitates participation by the public, which is an important element of transparency. Having meetings at other times, particularly during the working day, as you did recently with a 9:30 a.m. Thursday meeting, contradicts a commitment to transparency. Second, 4 of the 5 substantive items on the agenda for this meeting are listed for executive session. You've also gone into executive session in 2 other recent select board meetings. This does not reflect being transparent. It seems to me I remember Mr. Bocci and Mr. Haley stating not too long ago they were committed to transparency, including discussing open meeting law violations in open public session. What's changed? Third, there are the open meeting law violations themselves, which reflect violations of state laws requiring transparency. Specifically, Mr. Bocci, when you called Ms. McCarthy back in February, you created an open meeting law violation by causing communication among multiple select board members about the public's business in private, i.e. in a non-transparent manner. It now appears that when you placed that call, you were already aware of Mr. Haley's position in terms of the selection of the new town manager. Therefore, by simply making that call, you were violating the open meeting law. Given your years of service on this board and the multiple trainings you've presumably had on the open meeting law, you're placing that call as what the open meeting law calls, in its text, an intentional violation or a deliberate ignorance of the law. There's no excuse for that. Therefore, I call for you to step down as chair of this board. This is not the example or kind of conduct that our select board chair should be engaging in. Finally, I call for board members to stop having discussions among yourselves about the town's business, the public's business, outside of open public select board meetings. That's what transparency means, and that's how you would behave if you were truly committed to transparency. Thank you.
Sorry about that, thank you. Anyone?
Point of order?
Yeah.
Would you like him to repeat that? Because I knew you were really busy with your phone.
No, I heard him, thank you, I apologize, thank you.
Thank you for this opportunity. I'm Linda Snow Doxer, Beaver Road, and I'm speaking on my own behalf. On June 18th, Alicia Williams read Casey Moulton's accusation against me and others for having spoken with past Chair Jackie McCarthy about the town manager appointment. Unfortunately, I have found out that in response to one of many public records requests, Ms. McCarthy, in error, listed our phone call as focusing on the town manager. It did not. She has since corrected this mistake to Chair Bocci, Town Manager Cronalis, Town Council Ivrea Fried, and Town Clerk Laura Gem. In fact, however, it is important to state that as a town meeting member and a resident of Reading, I have every right to talk to any select board member about anything relating to the town. I did not respond immediately to Alicia or Casey because I feel strongly that this select board and this town needs to stop slinging allegations and insinuations and refocus on the real business of our town. We have so many vital and necessary projects underway. All of these other accusations are just distractions and time sinks. Unfortunately, it became necessary for me to put the record straight when Dan Dewar escalated this erroneous information to an OML complaint to the Attorney General, accusing my husband, Mark Doxer, of a violation due to serial communication. First of all, my husband and I are very careful not to discuss my conversations with other select board members. In addition, I do not share my public comments or letters to the editor with him before publishing. For instance, like my other public comments, this is the first time he is hearing what I plan to say, and he might have been nervous about it. Instead, we take care to ensure that we do not violate open meeting laws while also ensuring that I retain my right to have and share my own opinions, and therefore do my job as a town volunteer, as an independent town meeting member with my precinct, and as a resident of Reading. Secondly, as stated, there was no 14-minute discussion with Ms. McCarthy about the town manager decision. I have copies of my 3 emails with Ms. McCarthy leading up to her calling me on February 1st and her correction email. In fact, Mr. Bocci was on the original email thread to Chair McCarthy as I was trying to arrange a meeting with 2 of them to discuss the upcoming ad hoc commemoration committee presentation. Chair McCarthy took Mr. Bocci off of the continuing thread to avoid an OML violation. This negates Mr. Dewar's accusations. It's time that our town, and especially our select board, stop alienating our hardworking and essential volunteers and instead work hard to encourage volunteers to step forward to share their passion, their expertise, and commitment to our community. I am so grateful for what our volunteers give to our town without asking for anything back. The current practice of maligning volunteers does the opposite. It deters others from stepping up. I, as a citizen of Reading, expect all 5 of you to operate on fact, not innuendo or rumor, not political leanings or strategies of division, but rather to work together for the sake of each and every Reading resident and the betterment of our town. I challenge each of you to stop pointing fingers and instead start to work together. I look forward to working with each of you in the future. Thank you.
Anyone else in the room? Tara?
Good evening, Tara Gregory, Pleasant Street. You're all up here as elected officials and expected to set an example for how we treat our neighbors. In the past few months, members of this body have not followed select board policies. It seems that the chair of this committee, Mr. Bocci, has selectively omitted materials from discussion from select board packets ahead of a meeting, leaving other members, including Mr. Doxer and Ms. Herrick, in the dark and expecting them to vote without fully being prepared or informed. The most egregious example was when the board voted to move to executive session on June 4th meeting to discuss Mr. Dewar's OML complaint while inviting a private citizen to participate. Two members of this board campaigned on transparency this spring, Mr. Haley and Ms. Murphy. Yet you both moved to discuss the OML complaint in executive session when the public could not participate. A reversal from Mr. Haley, who demanded Mr. Brown's OML complaint be discussed in open session on February 17th. Yet a private resident was invited to the executive session on June 4th in what town council stated was atypical. I say this all not just to complain about the state of affairs. I want us all to do better, and it starts with our town leadership. Mr. Haley, you need to take responsibility for heavily insinuating Mr. Doxer was the reason for Ms. McCarthy's resignation, when it has become apparent through public records requests he was not involved. As a town official and a contributor to your own local blog, you have a responsibility to correct the record and apologize to Mr. Doxer, Ms. McCarthy, and the residents of this town for your behavior. Mr. Doxer has been a stellar volunteer for this town, as is his wife, Ms. Linda Snow Doxer. They do not deserve to have their reputations tarnished by false allegations. This is how we lose volunteers who are passionate about participating in local government and being a part of our community. I want to take a moment to thank the members of this committee for approving the ACE committee to honor Bill Russell and hope to do better moving forward. Thank you.
Anyone else in the room? Seeing none. Caitlin, anyone online?
No one raising their hand, no.
All right, thank you. I'm used to liaison reports, but this is not a normal meeting, so we don't have liaison reports. This public comment is over. So we have executive session, purpose 7, review executive session minutes from June 4th for approval and potential release. So I will entertain a motion, please.
Yep, move to enter into executive session under purpose 7 for the purpose of complying with section 22 of the open meeting law by reviewing the June 4th, 2024 executive session minutes for approval and potential release, to invite town council and town manager Matt Cornelis and executive assistant Caitlin Osella into the executive session, and to return to open session for the purpose of announcing the results of this executive session and to continue on with this meeting.
Second.
Second, any discussion? Seeing none, I'll do a roll call vote. Melissa?
No.
No. Mark?
Yes.
Chris?
No.
Karen?
I'm sorry.
This is to go into executive session.
What were the votes? I'm sorry.
Sorry, it's okay. Melissa was a no, Mark was a no. Oh, I'm sorry. Mark was a yes, Chris was a no, and this is to discuss our executive session minutes.
No.
These are all the same, sorry.
Yeah, okay, and me, well, it doesn't really matter. We have 3 no's, right? I got 3 no's? Yeah, all right, so, I'll do
You still
no.
got a vote.
Huh?
You still.
I know, I'll do no as well. I was making the count, because if I said yes, it wouldn't make a difference. All right, so we're not going to executive session. Go to the packet. So. We're all there. Any discussion? Any guidance on this?
Minutes?
Since we're in,
I would like to give some guidance.
yeah.
So
I don't see anything that could come about in these minutes that would be detrimental to the process that is before us. Did you have a question, Mark?
It seems that you're the only one who has them.
I don't have them
So how do you know there's nothing detrimental in there?
because I was at the meeting.
But you don't know what's in the minutes.
Do we think Caitlin is sandbagging all of us right now? Her
No,
minutes have
I
been
think-
pretty spot on.
If we're gonna be transparent, we should all see what's there.
I
Easily
agree.
done by going back and doing that.
Let him finish, I get your point.
Alternatively, they could be shown on the screen and we could see them there too. I don't see the problem. This isn't collective bargaining and all these other scenarios where this is gonna be problematic. We all know what went on during the meeting. I don't see anything that Caitlin's gonna put that we're not gonna correct in real time, that we're gonna do regardless. That's my outlook on it. I voted to go into executive session before pertaining to this because Mark Delaney was coming into the executive session and I wanted him to feel comfortable, which is abnormal than all our other executive sessions. So I am sticking now with the way I've always done it, with no special arrangements, that I'm not voting to go into executive session. I may be in the minority, but that's the way it goes.
Any other discussion? Oh, good.
So the problem is that a vote was taken to go into executive session for that meeting, which was abnormal. And that's created this problem for us now. And I think the only way, we can't get out of the problem, but the way to deal with it is we need to see what's there, make sure that we agree that it's accurate, let all of us see it and agree to it. And then take a vote to see if we're gonna make it public at that point, which was certainly a request that came from the public last time. But we've dug ourselves a hole, let's dig ourselves out, not by hiding and other things. Let's just see what's there, make sure it's accurate, and then have a vote to release it. I think the way to do that, as Ivrea said, is to do that part in executive session. Then ideally, if we agree to release it, we can come back out and release it.
Any other discussion, Melissa, Ken? All right, so we had a second, we had discussion, observation, so I'm gonna vote. Melissa,
No.
Mark,
Yes?
Chris,
No.
Karen,
Yes.
Carlo, yes. Sorry, folks, we are going into executive session.
I think that was the vote for reconsideration,
Oh,
Carlo. And
yes.
now you need the motion.
Oh, sorry, okay. It's the first reconsideration for me, so, I like to be reconsidered. Thank you. We're doing another motion now. Gotcha. Chris, read the same motion, please.
Yep. Move to enter into executive session under purpose 7 for the purpose of complying with section 22 of the open meeting law by reviewing the June 4, 2024 executive session minutes for approval and potential release, to invite town council and town manager Matt Cornelis and executive assistant Caitlin Nucella into the executive session and to return to open session for the purpose of announcing the results of this executive session and continuing on with the meeting.
Second.
He said, yeah. Any discussion? Seeing none. The vote to go into executive session. Melissa,
No.
Mark,
Yes.
Chris,
No.
Karen,
Yes.
Carlo, yes. All right, we're in executive session. If you guys want to hang out, we'll let you know when we're done. Ready? Okay. All right, we are back from our break. It is 8:10, 8:12, and we have approved our executive session minutes, and they will be released as soon as possible, if not tonight, by the latest tomorrow morning. So next item on our agenda is executive session, purpose 1, discuss and respond to open meeting law complaint filed by John Lippett on June 25th of this year. So Chris?
Move to enter into executive session under purpose 1 for the purposes of discussing and responding to the following open meeting law complaints. 1, an open meeting law complaint filed by John Lippett on June 25th, 2024. And 2, an open meeting law complaint filed by Dan Dewar on July 2nd, 2024.
No, we're only doing one.
That's what I got.
We're only doing one at a time, right?
Oh, sorry, I'm reading with the motions.
Oh, yeah, just the
Sorry.
first.
So, by John Lippett on June 25th, 2024, and to invite town council and town manager Matt Cornelis and executive assistant Caitlin Nocella into the executive session and to return open session for the purposes of continuing on with the agenda items. Melissa has a question.
Oh, sorry, Melissa,
She's seconding.
you mute? Oh, she's muted. Okay,
Caitlin has to unmute her.
all right, hold on. Not that she can hear.
I'm good, thank you.
Okay.
Sorry.
All right. Do we have a second? Second, Mark, second. Any discussion? Yes?
So, how do we wanna start dealing with these? We've been all over the board suddenly. It used to be that the standard procedure was to take these into executive session. Then there was some discussion of going into open, then we went into executive. So I'm just wondering, is there some thought that the board has on how to deal with this one today, and is that broader? So before we just kind of blindly take a vote, maybe we
Yeah,
should talk
no,
about it for a minute.
I'll start. My approach is I'm gonna take it complaint by complaint. And I think, I know what you're saying. And I think it's how the complaint is written, how valid we think it is as individuals, and how egregious it was, and that's how I'm approaching it. I don't want, we don't want, at least, again, my opinion, we don't want the public, in my opinion, seeing sometimes how we get in executive session, depending on the topic. That's just my opinion. I think we're entitled to executive session when it's warranted, and we put it to a vote. But I think I'm gonna call them simple open meeting law complaints, in my opinion, I approach it differently. I think with a more complex open meeting law complaint, I'm gonna approach that differently. That's just me. I'd rather have continuity, I think we all would, but I'm approaching it case by case. And I think you do to some extent as well, but I'm not saying that you do or don't, but I think we all have to decide what is the best for us and the public at that moment.
We asked Evia for legal feedback on what we're thinking here. She's still here? Evia, you still with us?
I hope so.
Yes, I am. So I mean, it's really a policy decision whether the board enters executive session to review open meeting law complaints. And like Carlos said, there may be times where it is warranted to have a discussion, frankly, in open session, but there may be other times where you do want to get the advice of counsel on whether a violation occurred, especially in times where it's a little bit uncertain and the board may want that confidential guidance from town council. So, as your legal counsel, I always like going into executive session, but I do see there may be times where it's warranted from a policy standpoint, and that's a decision for this body to make, not me as your legal counsel. But you do have the ability to go into executive session to hear my advice and feedback outside the public's ears.
Any other questions? Yeah, good for now.
Any other thoughts, board members?
Yeah.
So, case by case, so what are you thinking? This one, I like to be direct.
If you're named, does it have to go into executive session? If I'm named, does it get done in open session? Is it gonna be that?
Full disclosure,
Yeah.
on this one.
Yeah.
That is against me.
Yep.
Open session.
Okay.
I-
Nope,
I-
just wondering
I-
how-
I think
We have
it-
two great examples here, so
Yeah, I
understand.
listen, I can't, I'm not gonna prejudge anything until it's presented, and then we get the complaint and read it. And if I think it's, you know, really like what Ivrea said, if we need a lot of advice and a lot of guidance, then it's executive session for me. And that'd be my vote.
Yeah.
I'm not, you know, and you know, going forward, that's how I'm gonna treat them. No matter who it's against.
Okay, so my thought on this has always been, it is easier to have open and honest communications on delicate topics like an open meeting law complaint when we're able to do it in executive session, and that dovetails nicely with town council's general advice and sort of references your comments too. You kind of don't always know where the conversations are gonna go, but if you're in executive session and things get a little heated, then we can get our act together and then go present.
Yeah, you know,
To the public.
there's no heat in me right now, for this one, so I have no problem with
Alright.
doing that one in open session. And then when we go to the next one, I'll decide what to do on the next one. You know, I'm only talking about this one right now, so I don't wanna jump ahead. Oh, Melissa has a question, sorry.
Just for me, I feel like in the current state where I feel like residents are not getting all of the information but seem to have very strong opinions about things, I think we should be very transparent with them, and being an open session maybe keeps everyone on their best behavior and not go off a little bit, so I would like to see these done in open session.
Chris?
Thanks, Carl. Yeah, for me, it's always been any collective bargaining, et cetera, I always vote to go into executive session. Open meeting law stuff, I've always voted not to go into executive session. The exception was Mark Delaney, because I wanted him to feel like most comfortable when he came in here. That's the only difference. So you can predict the way I'm gonna vote in perpetuity, it will always be no. It doesn't matter if I'm named, my wife's named, Matt's named. Well, Matt, no, sorry. Matt, we're going in. That's kind of where I'm at with this. I think that, you know, a lot of these things have to get hashed out, and I do agree that we'll be on our best behavior in open session.
We've proven that. So
I agree, Mark.
I think that using the guidepost of if there is some merit in gaining confidential legal advice, then there probably is good reason to be in executive session. Otherwise, we may make a mistake. It's just too easy to make a mistake in terms of liability to the town, which we don't want to do. I think I can support it that way. And I think what that probably means is that, as you said, we look at each one individually and we probably ask counsel if there's something here that we, you know, probably merits having a discussion quietly, you know, so that we can make sure. that we're not
I listen, you know, this is not fun for any of us, trust me. I mean, you know, but it's gonna be 8:30 with 2 hours, and you know, this is not fun for any of us. So,
If I could real quick.
Yeah.
I think the barometer for me on this is whether or not Ivrea is giving us prepared legal opinions, 2-3 page things going into it, as opposed to absolutely nothing for any of these that I know of. So that's kind of another, you know, if she had prepared something where I think that it's gonna put us in a position, then I'm gonna change my mind, but we didn't get anything on either one of these that I'm privy to.
yeah, no, we didn't. So, we had discussion, any more discussion? We had a second. All right, so we're voting to go into executive session. Purpose 1 for John Lippett's complaint. Melissa?
No.
Go- Okay, yeah, it's not correct. Mark?
No.
Chris?
No.
Karen?
No.
Carlos, no. Okay, so we all have the complaint in our packet. And I have nothing to add. I'm kind of disappointed that we have a complaint based on a statement and not any law. And I'll just leave it at that. That's, my 2 cents. Anyone else? Chris?
Thanks, Carlo. I believe our executive session minutes that will be released today, tomorrow by Laura Gem adds clarity to this kind of scenario. I'm not even sure I can actually say what was in them, but for me, that kind of dovetails with what's in here. So I guess wait till tomorrow to see my response to that.
So I think that where we do need to take heed here is that we all are and should be familiar with the open meeting law and the basics. And we need to be careful not to violate it, at least not purposefully, right? So an occasional blip may happen, okay. But here, this one shouldn't have happened. And it's been discussed in a previous complaint to some extent, but we need to find ways to do better. And I think it's right that this is kind of, it has come up, and that it would be great if one of the purposes for executive session is that we can work out weird things sometimes. And here here we are. We're all where we are. So my concern is that we need to do better with open meeting. It would be great if the citizens of the community felt like we were, and therefore would have less desire to bring things up. But when they do bring them up, I think we need to heed a little bit what's going on here. So, this scenario was where, Jackie and I had been talking, it would have been great if a third person hadn't gotten involved. And both sides can respond to that in terms of, hey, it shouldn't have been listened to, it shouldn't have happened. But we need to do better. And I think that if that's kind of the result of what goes on here, I think that's right. In my opinion, did a violation take place? Yes. And I think we just need to do better in terms of, okay, how do we not allow that to happen going forward as best we can?
This violation?
Yeah,
The
I don't-
violation we already, you and I agreed to.
So to me, they're very much related. So this is saying that, hey, so the aspect of you and Chris having spoken, Chris alluded to it in terms of the response that's not yet public, so I think it has to get made publicly here, that you guys need to make that statement. And I may be convoluting things here a little bit. I think I'm bringing everything back together.
Yeah.
But, sorry, I'm just gonna make sure I've got it here too. So, sorry, I'm pulling back here a little bit. So this one is, I think it needs you guys to respond to, is the answer. It can't just be that, hey, you're gonna see this other thing coming. It needs to be a positive statement that gets made. And then, as we did with other ones, we go through, we say, okay, is that the feeling of the board?
Right, yeah,
I'm on track.
yeah.
Sorry, I'm pulling back from where I was.
No, I appreciate that, because you kind of surprised me there a little bit. Chris?
No, I was gonna say, I unequivocally disagreed with everything that Mark said, but he pulled it all back, so I guess I now agree with him again. But yeah, I immediately, when the statement was made, I called it out, disagreed with it completely and unequivocally, and here we are. That's it. So to agree that we committed something, we have to do better, et cetera, that's based on the premise that is a 100% certainty that happened. It did not happen. I was running for re-election, which everyone seems to forget. I wasn't talking to anyone other than town staff and Carla Nazaro about my town manager thing. That's it. I was speaking to nobody. So perhaps he implied that this took place and he was assuming whoever Carlo's voting for, Chris must be too. That wasn't the case with me. So to accept this on face value is completely unwarranted to me. It was called out then, it was called out in the newspaper by Carlo's comments immediately afterwards. We disputed it multiple times, and here we are 5 months after the fact with, oh, by the way, this happened. Not 5 months later.
So just to point out, we haven't treated the other violations in the same manner. So a statement, you guys, I believe, are making a statement, but you should make it here publicly.
Mm-hmm.
In other cases, you've had other members make statements publicly, and that hasn't been enough to dispose of the situation. It hasn't been treated the same way, including the last one that we just discussed. So that part's not okay with me. We just need to treat them consistently, right? If board members say no, as you said, unequivocally, then if that's good enough in one case, it should be good enough in all cases.
I think everyone's entitled to their opinion. I don't disagree with what you just said. I think it's a matter of what was said, how was it interpreted, and how you believe and feel. I totally get it. You know, here we are, 5 months and a few days later to Jackie's resignation, and we're still dealing with this. We need to move on, right? The town needs to move on, but here we are at 8:30. So I think, in my opinion, this open meeting law complaint is based on statements, not law. So open meeting law violation. So again, we can all, do better. Of course we can do better. I admitted to what I did many, many months ago. There's a record of it in the timeline of my text and my phone call, one phone call, and that's it. So I already admitted to that. This is totally separate. And to me, it's not an open meeting law violation. That's just my opinion. I did speak to Jackie. I admitted that. And it was about the process, not who she was voting for, not who anyone else was voting for. It was about the process, and we had 4 great candidates, and I needed some help. And then look what ensued. But I for this one, this individual one, I didn't appreciate it coming in. The residents have their rights, as we're gonna discuss the next one. But for me, this is not an open meeting law violation.
I'm not disagreeing. What I'm concerned with is that in a recent discussion, we did not heed what members of the board said and the majority of the board said there was a violation that occurred.
Oh yeah, that was recent.
And here, we're saying, well, some members of the board say it didn't happen, and therefore it didn't occur, then therefore
No.
it's not an open.
No, we didn't come to a consensus. I listen, that's different.
I'm not sure that it is.
Well, I think it is. Again, we have a difference of opinion.
Right. I just don't want a situation where
No,
we can't have a double standard.
no, I'm not
right?
saying,
If-
I'm
If
not,
board members are saying, I didn't do it, we're saying, okay,
there's a lot of evidence out there, a lot of stuff. Listen, I don't wanna get into that.
but we're back to allegations, not
Okay,
evidence.
Well, we have more to go on the agenda, but unrelated to this, there are, I don't know, facts, I guess. I don't know what the word you want me to use, but there's things out there that are real, and there's things that are he said, she said, they said, whatever said. I think that's where you're going from. And if one of us says, I did not do that, you have to believe me. And I say, hopefully yes, but sometimes there's other things out there that make me think differently. That I'm not saying that for any individual here. I'm saying that I was privy to a lot of stuff that other people weren't in the beginning. And I kept it to myself. So I'm just going from my perspective, and you're going from your perspective. So,
But I'm suggesting also that when we're dealing with something like this, opinions aren't sufficient, opinions aren't evidence, and we need to heed that.
I agree, this is an opinion, I agree, but I think it's a case by case basis, like I said before. I don't wanna, I think we're on the same page, but just a little bit different. That's all. It's not anything bad. I hopefully you respect me and I respect you, but I think we agree, but we're not fully there.
I think that's the case, as you're calling out that there are opinions or other things that may come in. I want to call out that opinions and allegations are just that, and only that. And where if that changes a decision or makes a decision or turns the corner from no violation to violation, in the absence of real evidence, allegations, but in the absence of evidence, I think we should be more consistent in how we deal with it. And I'd be uncomfortable if we find that, well, if it's majority or minority or opinion or not opinion changes how we view it. That, I think, would be a bad thing for the board. And I
Duly
just wanna
noted.
make sure we don't go there.
Duly noted. I'm not gonna argue with you on that one. That's duly noted.
Melissa has.
Melissa,
Just, quick thing is that, I would have liked to see this part of the conversation be mentioned by Mark Delaney, and it wasn't. That's first off. Second off, I believe that Mr. Bocci or Carlo already agreed to this violation, as you did, Mark, months ago, to Bill Brown's. So we're just kind of repeating the same thing. Are we not?
No, actually, that's not what we were just referring to. My
What are you
reference
referring to?
was much more specific to, we just dealt with an open meeting law violation from Mr. Doer addressed to Karen. And we went through
But what
this-
I'm saying here is that you and Carlo already agreed to a violation for this exact date, correct? When Bill Brown filed it, you guys already agreed to the violation.
Yeah,
So we're just talking in circles.
to be clear, we agreed that a violation took place.
Mhm.
I did not violate the open meeting law. So the implication is.
Then why did you agree to it?
Because it's clear that a third party came into the situation outside of my knowledge, and
Okay,
that was the
all right,
violation,
fair. Okay, fair.
not my actions.
Point of
Okay.
order, why does one person's name get mentioned and raked over the coals, and you're talking in riddles now? Why aren't you mentioning the
no one's
name?
name has gotten mentioned. What name has been mentioned?
So your name is not being mentioned in terms of the open meeting law violation. And Mark was mentioned and was raked over the coals with insinuations by Mr. Haley.
Linda, I gotta ask, are you
I
talking
just
about,
mentioned,
Are you
Linda, I just mentioned both Carlo and Mark. I'm not sure what
are you talking about this one or the previous one? I don't know.
Well,
what
we
you-
don't know what you're talking about because it's just a puzzle. To be honest, that's my point of information. If you're gonna have an open
Melissa asked
session
a question.
meeting, make it so we can understand what you're talking about.
Melissa asked a question to Mark, Mark answered, and now Melissa's clear on it.
Mhm.
So,
But we are not clear on which allegations you're talking about. You're talking about your executive meeting and not mentioning names, and
I
we're
was not
trying
talking
to
about
follow.
executive meeting. I asked a question regarding the OML that was filed by Bill Brown, and the board admitted to a violation. And I believe both Carlo and Mark were named in that OML, and that is what I was talking about. I was not talking about our executive session.
And I actually was referring to the complaint that we just dealt with that was specific to Karen.
And Mr. Brown's just.
And I did, you're right, correct me, you're right, Mark. I did also say that I would have liked Mr. Delaney to mention what was mentioned in John Lippitt's current OML when he spoke to us. I did say that as well, you're right.
I just wanna be clear that Mr. Brown's open meeting law violation did not name select board members. He asked for information,
Okay.
complaint.
I thought he did actually.
He wanted to know the two
He
names.
said, who are the two select
he
board
wanted to know the
members
two
that
names.
talked to Ms. McCarthy?
Oh, right, and then he
Yeah.
contemporaneously added his desired punishment.
Forgot that
Yeah.
detail.
all right, let's bring it back to this complaint. Chris?
just piggybacking somewhat off what Melissa said. The difference with this is that the only person that could prove otherwise, whether or not this actually took place, which would warrant the entire complaint, we had in executive session, and he could have answered the question. And it was only brought up after he left, not before, after he left. That's it for me. It could have been point blank, this happened, and then Mark would have said yes or no, and it would have been put to bed. Instead, it's waited until after he leaves to drop a 5-month-old bombshell that apparently occurred. To me, it would have been more warranted to have that happen before he left. And there's a reason, in my opinion, that it didn't. And that's where I stand with this.
Sorry, so it couldn't have happened that way because we were in executive session.
It could have. Karen refused to speak until Mark left.
Oh, here we go.
The executive session part is irrelevant to this. The point here is that the public didn't know what was stated and still doesn't. What happened in the executive session, they have no idea yet.
We were in
It's
open,
about to be
we were in
released.
open session for 20 minutes, roughly.
Right, but the comment about where this came from and it would have been resolved in executive session,
It was,
it's not okay because public wasn't invited to executive session.
No, I'm saying, with you saying we have to take everyone's word at face value all the time. Why are we delineating and picking and choosing? Why is this person named and what this one is? I'm just rationalizing it. We had the person here that we could have proposed the question to put it to bed, and we chose not to. We, maybe Karen, could have mentioned it then, and I would have unequivocally said, bro, that didn't happen. But that opportunity did not present itself. It's only after he left does this happen. And to me, that doesn't pass the smell test, Mark. It doesn't.
I'm not following this. How does this even relate to that executive session?
Because it's naming Karen's rebuttal in the executive session was released, and then that's why this OML was filed. Because of the communication allegedly that Carlo and I had. That's why it was filed. And the person who could have cleared it
Public
up,
comment.
This is in relation to Karen's letter.
So, right,
Her
and again,
response.
what does that have to do with the executive session?
because it was.
I think he's
nothing.
referring, the open session, executive session is one thing. When we voted to go into executive session, we had discussion, that went on for like 20 minutes.
Right,
And Delaney was in the room.
right?
I'm not putting
Correct.
words in Chris's mouth. I think it's what he's referring to, I'm not saying it is.
So, a member of the public, different members of the public have brought forward complaints and concerns, right? This is the third or fourth one that we're dealing with right now on similar topics,
Mhm,
right?
mhm.
And my concern is that in some cases, we're kind of saying, well, the people involved said no, so it's done. In other cases, we're saying, I don't care if the people said they didn't do it, I think they did. So I think it's a violation.
Yeah, well summarized.
The difference, Mark, is Mark was sitting right there.
It-
That's the
this is-
difference. We
this has
never have
nothing to do
other.
with him.
It absolutely did.
No, it has nothing.
Nothing to do with
Because
He's
the
mentioned
person-
in the complaint.
he's
though.
mentioned-
mentioned in the complaint.
That is the tip of the entire
We're
complaint
not
is
here to do an
allegedly.
investigation. You guys
It's not an
wanna do
investigation.
That's what you wanna do. You wanna like bring in
I'm just saying,
witnesses, and that's not
you-
how this works. Someone files an open meeting law complaint. If we were in executive session, usually she would comment as to her thoughts about whether she thinks this is a valid complaint. I mean, we haven't even gotten to that point. That's how we would handle open meeting law complaints in executive session. We get some advice from counsel, whether she thought it had merit. And we're not able to do this because we're going back and forth,
Right.
like looking to call witnesses.
I'm not looking to call anybody. I'm saying the guy that could have cleared this all up was sitting here, and this gets dropped after he walks out of the
That's
room.
not how you respond to an open meeting
Well, I'm just saying, that this is my opinion on the topic.
Yep.
For Mark to just say, we gotta do better, we can't have this happen, we can't have it happen, it didn't happen, Mark. I know that it didn't. I reiterated 100 times, I was the only person not implicated in the meeting law complaint.
You did say
I said it
that.
100
Yes, you
times,
did.
and you know whose name is not in any of these public records requests? Chris Haley. Everyone else is mentioned,
Chris,
because I didn't do
for a second.
anything.
this is related to you only because your name is here also, right? Here's the situation that I'm trying to highlight, and I guess I'm not doing a good enough job yet for a second. If we go through this process and there's an allegation of something and it's a board member, you did X, and the board member says, I didn't, there has to be a consistent way of dealing with that. Not, well, I don't agree with you, I don't believe that, therefore it's a violation in one case. And in another case, I didn't, no, so it's not a violation in that case. I'm asking that we deal with things more consistently, have a way that we're gonna do it, but right now, we just have an example of one that was dealt with a certain way, and we haven't voted on this one yet. But it feels like it's gonna get, I have no reason to doubt what you folks haven't actually said but should. I have no reason to doubt it. And I would accept it. I'm just uncomfortable that when the shoes were on different feet, that's not how it was played out. It was exactly the opposite.
Was exactly the opposite if Bob Holmes was replaced with Mark Delaney. That's the difference, Mark. You never get an accusation made and the person who can clear it up is sitting right there to be able to tell you it didn't happen, it did happen. That's the difference. This is a he said, she said, 5 people removed before it ends up getting into this. Karen told Jackie, who told Mark, who told Karen, that's like the loops that you have to jump through for this to happen. I agree with you that we need to have consistency. But in this case, I'm just offering, to me, we had the opportunity and he walked out of the room. And then it happens. To me, I'm just pointing that out. We can agree to disagree.
That's all he's doing.
Yeah.
I'm just pointing it out. You can draw on that however you like. We had the opportunity to ask him anything, to a point. And only after is it revealed that, oh, by the way, this happened.
So you're complaining about a resident filing a complaint and not doing something that you said might have cleared it up.
No, but they had no way of knowing that transpired. Only Karen in this scenario would.
But it's
I think-
Karen's responsibility to have gone ahead and figured out what might have been said, therefore asked the question so that a complaint might not have been filed.
You're making it
Mark,
seem.
this was from months
this
ago.
is-
All of this is from months ago.
I know, but the letter was more recent. The response letter that this is part of was more recent. Yes, this was many, many months ago. But the reason we have this complaint is that Karen did a response to the OML filed by Dan, claiming that I said things, and I said I didn't.
Not claiming
I
you
didn't
said
claim
that.
that you said things. I made a statement about a conversation
Well,
that we
okay, sorry,
weren't
sorry,
privy
you're right,
to.
you're right,
I
sorry,
mean,
you're-
I
You're right.
have a truth. Chris, you have a truth. I get it. You have a truth. But what Mark is saying is that in our last open meeting law violation, my truth didn't matter and you voted that a violation occurred. And what seems to be, my concern, and I think I share it with Mark, is on this one, your opinions will matter and no violation will occur. And then we get to the other one tonight and your names aren't mentioned, so a violation did occur.
There's a lot to this, I'm not gonna deny that.
All right. I think we should do this in executive session. I really would like to hear from town council on some of these.
I'll correct what I said, you're right. This is a statement that you heard, right, I'm sorry, you're right.
It was a conversation I had.
Right, exactly, so I misspoke, so I apologize for that. What I'm saying is that we have a violation here in front of us,
A complaint.
a complaint based on a statement that you believe happened, right? That you were part of.
And the previous
You're part of
OML complaint referred to a letter to the editor, which is like,
Well, again, we're not,
Kind of the same thing.
we're gonna be here all night if we're gonna do that.
well,
Yeah,
we're
it's-
trying to, we need to deal with these consistently, that's what Mark is saying.
It's hard to do sometimes. Listen,
Yep,
it's hard to
fair
do
enough,
sometimes.
Fair enough,
I
can we,
can't,
can we change our minds and go into executive session?
we're not perfect. We're not
So
perfect.
I can,
Rivia, go ahead.
yeah, I just have that one statement to make. So I think, the question that you posed is, did a violation occur? I'm not gonna make a finding one way or another, and I don't think I would do so in executive session either. I wouldn't take that position. I think if this conversation between Carlo and Chris had occurred prior to Carlo speaking to Jackie, that would have been a violation. If the conversation didn't occur, then it didn't occur, and we've already admitted that there was a violation back in the day when Jackie and Carlo and Mark had a conversation. So that's already been dealt with. So the question is whether this conversation between Carlo and Chris has occurred. Now, the Attorney General, when there are generalized statements like this about an alleged conversation, will defer to and credit the board member's statement about what transpired. That is the AG's position. Absent other information, they credit the statements of the board member. So I just suggest that, that's information for you guys to digest as well. That is what the AG would do if they were reviewing the matter here. Chris is saying pretty firmly that he did not talk to Carlo about the matter, and the AG would accept that absent other information.
Okay. I don't think we need to go into executive session, but we can do another vote, but I am ready to, address this, but that's just me.
Can I ask a question?
Yeah.
Ivrea, do you have any technical concerns with this complaint?
No, it doesn't have to reference a specific provision of the law, Karen. I know that was discussed earlier. The
Or
AG recognizes
timelines?
that.
Okay, dates, timelines, anything, things like that.
So generally, a complainant has 30 days from the date that the alleged violation is knowable. In this case, they're arguing that it wasn't knowable until the letter was published. I think my biggest concern is this about a violation that has already occurred? I think we could take a position potentially that this has already been dealt with, but Chris is saying very clearly on the record that this conversation never occurred. And so I think that, the board could respond, there was no violation. Chris never spoke to Carlo. We've already dealt with the prior violation that involved Carlo, Mark, and Jackie. And Mark, I recognize, it wasn't your intention to violate it. I'm just using it generally as the three individuals.
Yeah, Mark made that statement a while ago, and he's 100% accurate. So Melissa, do you have anything to add to that?
No, I do not, right now.
Yeah, I did not blurt anything out. The main part of the conversation with Jackie was the process and her being on the search committee. And that was it. And we talked about other stuff, but that was it. I was struggling, because, like I said earlier, we had 4 candidates, 1 internal, and, as some of us do over the years, we reach out to the chair because they're the chair, and they value their opinion. Sometimes that happens, sometimes it doesn't. Mark and I spoke a lot when he was chair, because I valued his opinion. And that was our relationship. And I appreciated it. So, and that's it for me. Jackie and I spoke about certain things that weren't OML violations because she was the chair. And then we spoke about running, we spoke about pickleball, we spoke about whatever, but it's this one particular here is a little frustrating, but I understand it. I am not, I have nothing against Mr. Lippett for filing it because it was new information based on Karen's response. But, we can hopefully not discuss it too much longer, but I think a violation was not committed. That's just my opinion. Yep.
Okay, so I'm just looking at the last complaint that came in from Mr. Dewar. And I made a statement that there was no serial communication and that there was no intent, and we had Delaney, and we involved an atypical resident involvement. But what the board decided was that my statement of what happened wasn't good enough and a violation occurred. And I think you're kind of saying the opposite right now, that we should trust that your statement.
This is my opinion, Karen. We shouldn't be bringing in another.
Well, this gets back to Mark's consistency.
I'm not saying Mark is wrong.
So sometimes the select board member is going to be believed, depending on who it is, and sometimes the select board members are not gonna be believed. And we have another open meeting law complaint before us tonight, and so we're gonna have to do it for the third time. So I think that's why Mark is asking for some consistency.
I understand that, and you don't have to believe me. That's your opinion.
I'm not even talking about whether I believe you or not.
Well, you're bringing
I'm
up
talking
Dan Dewar's complaint, which we shouldn't be doing.
I'm talking about how we treated a matter that's not that dissimilar. We
We all have
decided to
our- we all have
disregard,
our
this
own
board
opinions.
disregarded the select board member statement and voted that a violation occurred. So if we're gonna be consistent, then on this one, we should think about disregarding the targeted named select board member statement and voting that a violation occurred. Cause they're very similar, and that's just, and again, the third one we have to deal with tonight, it's also very similar, it's based on statements.
Again, we'll address that very soon. I think we have to focus on this one. Your point is taken. Mark made it several times. I think you don't have to believe me.
I didn't say, it's not about me believing,
I
it
know,
really isn't.
but you're kind of implying it, and that's fine.
I didn't file the complaint, the complaint
right.
was filed, we have to deal with what's in front of us.
Right, let's deal with the complaint. I am saying I did not commit an open meeting law violation. Chris is saying, and it's up to the board to respond as a body. Not me, not you, not Mark, not Melissa, not Chris. As a body, we have to respond.
Yeah.
And then we'll go on to the next one.
Yep. Okay.
All right, how do we,
I'll make a statement, so I take your folks' word that you didn't do what's being alleged here.
that's,
You said, I believe you now have said that you didn't. I take your
no,
word.
that's great. I think we need to respond to this. We had this special meeting, so to meet the compliance of 14 days. Our next meeting wasn't gonna do it, so, anyone else wanna, I think we could, I'm not saying Mark speaks for all of us, but, Melissa, do you have anything to add?
I don't at this time, thanks.
So we need to get a response to Mr. Lippett.
Right, so you already have a motion written?
I don't, but I was gonna say, I know Avery was gonna say, authorize Avery Freed to respond to the board, and we're just gonna say that based on a consensus of the board, or whatever the vote is, that we don't believe an open meeting law complaint occurred.
Open violation.
Violation, yes, occurred. Did I get that right, Avery?
That's great, yeah.
I'm fine with that. So moved.
Is there a second?
Okay.
Any discussion? Okay, anything to add before I do a roll call vote?
No, I understand my direction.
All right.
If the vote goes through.
Thank you. Melissa?
Yes.
Mark?
Yes.
Chris?
Yes.
Karen?
What are we voting on? What's the motion?
That an open meeting law violation did not occur. And Avery is gonna respond on our behalf.
I'm having a real problem with this because I was sitting in this position just a couple of weeks ago and I was not offered this courtesy. It didn't matter what my truth was, it didn't matter what my statement was. You and you and you all voted that a violation occurred, so I don't really know what to do. And I'm also looking at another violation that we have to deal with after this, and I kind of have a sinking suspicion of how that's gonna go. Mark and I are named, and I am pretty sure that you and you and you are gonna vote that a violation occurred. So help me get over this.
I'm not gonna discuss what's gonna happen in the future. I think that anybody who would be listening or watching knows exactly how I'm gonna vote on that, particularly what was handed to us 30 minutes, well, I don't know, 3 hours ago at this point, before the meeting, which apparently is a brand new thing that we're not supposed to be shocked with, that we got, which changes the way that things would be voted upon.
Oh, God. Do you have
I didn't know about any of this stuff.
This is new.
So obviously, what am I gonna just be like, you know what, sorry, I don't believe any of what was passed out to us, a violation of
This
court.
has to do with a statement that a member of the
Yeah,
public made.
but that's why Mark is named. I'm not gonna, we can get over that when we get to it, but
okay,
there's no way that I'm gonna be like, you know what, I'm gonna disagree with all of you people, including this, and just vote accordingly, no way.
So,
I don't,
okay,
I
another
take
option
offense to
then.
thinking that
Okay,
I'm just gonna
alright.
do that.
Linda Snow Ducks already made a comment.
I know.
This is,
It's, like I said, I didn't,
So that's good, so you can let Mark off the hook and say no violation occurred there, but you can still say, yeah, we like the way Mr. Dorr wrote this, so Karen, another complaint, Karen, yeah, you made another violation, like you're gonna disregard my statement. That's what I feel is gonna happen, so
I-
maybe
I
I should
don't
just
think-
abstain from both of these, because I don't wanna make this board more divisive.
I don't think we're
You're
gonna,
not helping me
we
not
are
do
not,
that.
we are, I am not gonna disregard your statement at all, Karen. In fact, it is the entire
I can't
basis
be a part
of
of
what.
this, I really can't,
what's-
this is a road to nowhere.
so do you vote no? Please make a decision.
I'm gonna abstain, I'm sorry. This is not a process that I can deal with.
Okay,
It's not consistent.
I vote no, so we have 4 no, God, what am I doing? Am I doing it wrong?
You wanted to
401.
vote, I think you were trying to say that an open meeting law violation did not occur and you want Andrea to be able to write that up. I
Yes,
think a
I'm
vote
voting-
of yes would be what you said for that.
sorry, Karen was gonna be, I thought no, but she abstained. So yes, we have 4
Yes.
yes, oh my God, and 1 abstention from Ms. Herrick. Okay, on to the next one, fortunately.
Ready?
Yes, please.
Move to enter into executive session under purpose 1 for the meeting, for the purposes of discussing and responding to the following open meeting law complaint filed by Daniel Dewar on July 2nd, 2024, to invite town council and town manager Matt Cornelis and executive assistant Caitlin Nocella into the executive session and to return to open session for the purposes of continuing on with these agenda items and continuing on with the meeting.
Second.
Second. Any discussion? Melissa? No discussion?
No discussion,
All
no
right.
discussion, no.
All right, this is a vote to go into executive session. Melissa?
No.
Mark?
No.
Chris?
No.
Karen?
No.
Carlo? No. Okay, we are doing this in open session. Okay, so we've all had the complaint in the packet. There's some things in the packet that are relatively new, I would say, or very new. And I agree with Chris that this open meeting law violation is has 2 parts to it, and I based on public comment earlier and based on a few pages that we've been given, I would not have any confidence that Mark Doxer committed serial communication, in my opinion.
Can I ask a question?
Yeah.
I don't know what you guys were handed.
Oh, that's right, I'm sorry. We were handed an email from Ms. McCarthy that we did get. That's basic, huh?
That you received originally, not us.
I'm
We
sorry.
got it now.
Basically correcting the record, an email from Jackie McCarthy correcting the record of timeline and Linda Snow Doxer's reference in the timeline in our packet that there was discussion regarding the town manager search. And Jackie corrected that record, and so did Linda Snow Doxer correct the record, that
Okay.
it was not about the time, and so that's been withdrawn, I guess, from, so if we were looking at the timeline that's in our packet, we should disregard that
Okay.
reference.
Okay, thank you.
Carlo, can I just make a few comments
Sure.
on this? Okay. So when I was looking at this complaint, I sort of broke it down into 3 parts, and I'm gonna actually go from the bottom up. So the first component was that Linda Snow Doxer had spoken with Jackie, and I understand the record's been corrected, but I do just wanna clarify that spouses or partners of board members do not lose their right to communicate with other elected or appointed officials just because they are in a relationship or married to a select board member. The violation could potentially occur if the select board member is directing their spouse to have communications whereby they are conveying their select board member's views to another select board member. And so it's really about what is the intention of the select board member to utilize that spouse to facilitate that communication. And I know that, you know, Linda and Mark have said numerous times that they don't talk about board matters, but I just wanted to be clear that, you know, Linda or any of your partners or spouses do not lose their rights to advocate on behalf of the town. So I did want to make that clear. The second part of the complaint, Mark Delaney shared with Karen that Chris, Carlo, and Jackie were voting for Matt Cornelis, and then Karen asked, you know, Mark Delaney, how could he know this? And so there's an assertion that a violation occurred. To me, this is just a reiteration of the prior violation that we already discussed. And so I do think that, you know, we can recognize the board already dealt with this matter. I don't think it counts like twice against Karen. It's just the complaint is the same. I don't see anything new there. So that's how I would suggest approaching that component, unless the board wants to take a different view on whether or not a violation occurred at all. And then the third component is that, you know, Karen communicated with Jackie via text messages. And while that complaint relates back to Bill Brown, this is slightly different because Karen, as we know, has stated time and again that she hadn't spoken with Jackie. So I do think that this could potentially be viewed by the Attorney General as a new violation if it is found that that communication occurred. So I do think that that one at least warrants some discussion amongst the board members. Happy to answer additional questions.
Thank you, Ivrea. Yeah, this was a 3-parter as well, and I, speaking for myself, I fully agree with your first 2 statements about the middle, part 2, being a double, similar to Mr. Lippitt's, and I already discussed the last paragraph, and the first paragraph is in black and white. About how Karen lied to the board, so that's a lot different.
I'm gonna take offense at that statement that you just made. I think it's very antagonistic.
You didn't lie to the board?
I did not lie to the board. This is a whole new allegation. What's today? June 9th, 9:05. Thanks, Carlo.
Oh, these weren't your texts? No response is a response. So these weren't your texts. These were made up, and you didn't do this. Is what you're telling us.
Carlo, the original open meeting law violation asked for the 2 select board members that spoke to Jackie McCarthy about the town manager selection vote. I did not speak to Jackie McCarthy about the town manager selection vote in the specific time frame that she said, and I nowhere in those texts does it say, you need to vote for this candidate, I'm voting for this candidate. So I think you're really mischaracterizing the nature of conversations that I had with Ms. McCarthy. And I think it bears, if you think a violation occurred, there were two people communicating. So there were two people involved in a violation. And you vote however you want.
No, now there's 4 people. Jackie,
And-
me, Mark, and you.
Can I ask a question?
Yeah, Melissa?
I don't have it in front of me and I apologize, I should have, but Karen, in your statement, did you say that you did not talk to Jackie McCarthy?
Okay.
In your statement that we attached to Dan's first OML?
I can answer it because I have it up. It's in there multiple times. I never spoke to any select board members about the town manager selection.
That's what I just said. That's correct. That is
Votes.
absolutely correct.
Are you playing semantics, Mark, with the
No,
word
no,
vote?
I'm being very
It's-
specific. I'm being very specific. The open meeting law was about
Ugh.
people having conversations about how they were gonna vote for the town manager.
This
So
was,
that I
this was,
repeated
these text
consistently.
messages are deliberation on candidates. By
We
you
voted
saying
blank. I
someone is
already-
too young, that shows that you're not favoring voting for them. And like,
Wait, you weren't involved in that conversation and you're just reading into it.
I'm reading the text, it's in black and white. You're
Yep.
denying something
And
that
there were
actually happened.
two select board members involved.
God.
And there are no statements in there that say who either of those select board members are gonna vote for.
But you're masquerading it by
I'm
By
not masquerading
pushing candidates,
anything.
by pushing candidates away from it.
I
Saying somebody
disagree.
is too young.
I disagree, and these also
Oh my God.
occurred a number of days prior to the statements that Ms. McCarthy made that really, and then were preceded by her resignation. I would like to say that neither Ms. McCarthy nor myself believed that these were conversations related to the town manager vote, and that's my statement.
It says Clancy Main sunk his ship
Yeah.
when he didn't go with Sharon, et cetera. On what
Who
planet
made
is that not
excuse me,
deliberation?
Excuse me, who made that text?
That's Jackie, but that's still
Okay.
you. You were
It's-
involved in it.
It's texts,
I
yeah.
cannot believe, like you
Going
told,
nowhere.
I cannot believe on July 9th, you are using the selection vote with what's transpired in these text messages and playing semantics with the word
I can definitely
vote.
believe that you are gonna vote that I
Unbelievable.
violated open meeting
absol-
law
it's in
again
text. It's
without
bel-
putting any thought into it.
It's in text, Karen.
Let's just go home.
Karen, you said you never spoke with anybody, you texted with Karen.
About the
over-
town manager vote, Chris.
Just the
Don't tell
candidates themselves by pushing certain ones in a certain direction.
Chris, I
that is not-
released
oh,
a statement,
Yeah, you did.
I did. And again, so my statement isn't good enough for you.
Not when there's,
No,
not when there,
never.
not when
It's
there's
never.
text messages
Right.
contradicting exactly what you just said.
I
Contradicting. You
guys
never spoke to
are gonna
anybody.
vote how you vote. I kinda laid
Oh
out
my
how this
God.
was gonna go and how we're not being consistent.
I have, this
And
is a
Mark has
new level
asked us
of
to be
putting this
consistent.
on us as being the
All right,
problem
let's
and
calm
not
down.
you.
Let's calm down, please.
Wild, absolutely
Karen,
wild.
Karen, I have one question for you.
Can I ask a,
Hold on, Melissa, I have one question for you.
Yeah.
In your response, you included the back and forth with Mark Delaney. Why didn't you include these?
Why did I not include
Yes,
the
these
text that Jackie provided to a PRR request and that Alicia Williams came and deposited, from Casey Moulton? I don't understand the question. What? I
Oh my-
don't
oh my-
understand the question.
Wow. You had an opportunity to come forth in your response.
The open meeting law complaint filed by Mr. Brown said, I want to know who the two select board members are that talked to Jackie. Jackie said, I committed an open law violation. I spoke to select board members about the town manager vote. Jackie did not provide these texts until they were PRR'd because neither Jackie nor I believed that they were relevant to the town manager vote, okay? If you guys have a different opinion, that is totally fine.
Why did Jackie provide these? She didn't have to
She
provide
had
them.
I understood she had a public records request.
Right, but if she felt they weren't
I
related to the
underst-
town manager search, why did she
No, the
provide
public,
them?
I haven't seen the public records request. The public records request says provide, I was PRR, did you know that? From one of the candidates for the finance committee, I was PRR'd. The form of the public records request said, I want all Karen's texts related to, I don't even remember what it was, from March 1st to March 15th, between so and so. Depending on how a public records request is worded, and I've been the subject of at least 5 of them, those are the texts you provide. So I recently got another public records request asking for all of my texts between myself and the chair of the Killam School Building Committee going to last year. So there's no filtering out, there's no judgment calls, you just dump the texts, okay? So Jackie did not initially bring any of this to light. Neither one of us believed that we committed an open law violation. We're not the ultimate decision makers, but I might stand by my statement. I did not speak with Jackie McCarthy. I did not make determining statements saying, you need to vote for this person, I'm voting for this person. I just didn't. So you accusing me of lying to the board is just antagonistic and not gonna help us get to a better place and dig us out of the hole.
You had many opportunities to say you at least texted Jackie, and you never did. That's all. That's all.
I texted Jackie a whole bunch of times for the past couple of years that I knew Jackie about a whole different kind of topics, just like you said. Yeah, lots and lots
And
of
this
texts.
topic was very specific about our new town manager.
Yeah, no, I think
Okay.
I'm gonna disagree with you.
That's fine, that's fine.
Can I speak, cause I can clarify
yeah,
something,
sorry,
I
go ahead.
actually have a copy of the request.
Go ahead, Melissa, go ahead.
The request that was made, actually was specific. It said that, I'm requesting a public records request of a cell phone logs, text messages, and or email to Jackie McCarthy, former select board chair, received from January 30th to February 7th regarding discussion of town manager vote. So it was Jackie's choice to,
Melissa, I haven't
produce your
seen that
text.
public records request. Were you named in it? How did you get a copy?
I got a copy from Casey, I asked her for a copy of it before tonight's meeting.
So, and when was it dated?
Which I'm allowed to do, I'm allowed to ask someone for a copy of the request they made. But I did actually have a question, cause
What
I
was
was
the,
going
excuse me,
to
what was the
defend
date?
Karen, but
What was the
I'm sorry,
date
say
of the
that.
public records request? What was the date of that public records request?
Let me see if I can see the microphone here, sorry. It was made in April of 2024, April 22nd, 2024.
So prior to that public records request, Jackie had presumably reviewed her own texts as I had reviewed mine, and neither of us felt this rose to the level of an open meeting law violation.
I'm not arguing that point, I'm just stating what was requested and what was given, that's all I'm
Thank you,
saying.
that's helpful.
My question to Ivrea is, because the board found the open meeting violation on Dan's previous request, if we're just looking at this as we believe Karen, I don't wanna say, maybe chose not the right words for her statement, does this make it another violation? Or is it still piggybacking on the original one that Dan filed against us?
Do you mean Bill Brown, the first request?
No, I mean Dan Dwyer. Like, so we found that the board, there was a violation for Dan's original. Now, I'm saying that, is it a violation if someone just misspoke in a statement that they made? Is that a violation of open meeting law?
So the open meeting, I can't really answer that question. What we can look at is what Dan's request was about. And Dan's request was the use of a third party to facilitate serial communications. What we have here is direct communication between a select board member and another select board member. So I do believe that they are distinct issues. Now, Bill Brown's complaint did pertain to, and I just pulled it up. So his complaint was the chair of the select board, Jackie McCarthy, stated that she violated the open meeting and then resigned as of February 7th, 2024. Since it's a 5-member body, 2 other members must have been involved. I want the names of the 2 other members made public. And so the question is, do we look at it as this was a board violation that occurred around that time period, meaning we've already addressed it if we do find that Karen's text messages constitute a violation, and therefore this is all part and parcel of the same complaint? Or because Karen made statements that she never communicated with Jackie, and now maybe not to be determined, we think those statements are now no longer true, and there were communications that a violation can be found at this time now. I did some digging, I looked at some AG decisions, there really wasn't anything on point. All of the cases that pertain to repeat violations were really like the same. It wasn't new information coming to light where new select board members were brought in. So we don't have any history here. I think I would feel comfortable making the argument that it's the board that violates, and we've already discussed the board violation that occurred back in January and February. However, if this body wants to take a different position, it's up to you how you want to respond to the complaint. You could say, we've already addressed this, we commit to future compliance, and move on, or you could say something different that addresses kind of the new facts that are presented tonight.
Can I just ask one more question, a follow-up to Mr. Brown's OML? When the board responded, and I apologize, I don't know this off the top of my head, but did we get Jackie's input on Mr. Brown saying the 2 members that were involved, or did members of the board just assume they were the members that she was speaking of?
So I never spoke with Jackie, and she didn't attend the select board meeting. I defer to other board members as to what their assumptions were.
Okay. All right, thank you.
Chris? Thanks, Carla. So, Ivrea, did you review the text messages as part of this whole process that are in the packet?
I did, and I do think that the AG wouldn't parse it as fine-tuned as Karen, I think, is trying to argue here. I think that the AG would likely take the view, was the town manager search process discussed? Were candidates discussed? Were these matters that were outside of administrative scheduling? And whether they came from Karen or whether they came from Jackie, I do believe that there were things in those text messages that potentially cross the line into substantive discussions about the town manager search. Now, I think that goes to the question of whether or not this is just part of the same violation that we've already disclosed and addressed. And, I think this board has really committed to future compliance, and I know you are all working so hard. I'm happy to give an open meeting law training. I know the Attorney General is happy to come out and give a training, but I do think it would be reasonable to take the position that this is just all the same violation. But if you want to take another view, it is your decision. It's your response as a body to decide how to move forward.
And so, do you think that what's in the text messages counts as deliberation on the town manager?
I think that the AG would likely find that they are a deliberation pertaining to our manager search process. Text messages and emails are deliberation. It doesn't have to be an oral communication. That comes from the statute and the regulations.
Seeing what I said previously, Karen, was about I wasn't going to vote to remove you as vice chair based off Dan Dewar's open meeting law complaint. That's what he wanted. I said unequivocally I wasn't. There's no contact with Jackie McCarthy. She didn't do it. We're not going down this path. I was the only one that said that. Nobody else. Just me. And here we are. I look like an idiot for taking the high road and being, giving you the benefit of the doubt. And here we are, following up on this, and it's proven to be otherwise. We can use semantics with whatever words it is, lie, mistruth, misspoke, whatever it is. It's crystal clear black and white in here. It's very simple. So I think for me, I think in the spirit of putting a period and moving on and just putting an end to all this stuff, for me, it becomes very simple, which is a later on agenda topic item, is that I'm not gonna vote, if vote is on the next agenda, to remove you from vice chair. If, in the spirit of just putting a period and moving on and accepting this, that you actually agree that you did speak to Jackie about the town manager search. That's it, because then I wouldn't have removed you, I wouldn't have not voted for you back then in February, March, whatever date it is. My vote never would have changed. You still would have been vice chair, we wouldn't have had all these months worth of stuff. You just have to own up to it. That's all, and we can move on. That's all I'm asking. Just, all you have to do is say yes, and we can just move on. That's it, Karen. It's in print.
So did you just
heard what-
threaten to remove me?
I did not threaten to
I think you
remove you.
just
I
did.
just said, in the spirit of
think you
moving
just
on,
did.
Karen, because we
No,
don't
I
wanna
think you
just
just
keep.
threatened me.
Oh,
Yeah.
clearly, I threatened you and all.
Well,
And-
I kind of already knew where that agenda item's going, so I can't
It
say
is-
that I'm really surprised. I mean, you know, it's just
I'm-
every meeting is so much
I'm
fun.
offering you an olive branch.
I don't feel, this feels like a threat.
Independent,
This feels
an
like a threat.
independent person just told you it's deliberation, Karen. That's it. So you can choose to accept it or not. That's all. We don't wanna keep doing this. I don't wanna keep doing this.
I don't.
No,
So
Nobody
I
does.
don't have a problem if I am not an open meeting law expert. I don't have a problem if the Attorney General, in everyone's opinion, thinks these were too close to the line. If they were, they were. I'm happy to take that under advisement and do better going forward. They may be. I'm not an open meeting law, but I'm not gonna negotiate with you over this.
I'm not asking for I'm just asking for us to move on, Karen.
I would
That's
love to move on.
Just
I would
ex-
love to have my statements actually carry weight occasionally
Not
and
when
not
there's,
like,
they're carrying weight. They're in black and white in print
but not
for
the
everyone to
statement
see.
that I was told that you and Carlo, I already knew what was going on because I was told that by Mark Delaney. That was absolutely unequivocally.
And it was immediately contradicted. It didn't wait 5 months later to spring this up out of the blue.
All right, Melissa has her hand up. Sorry, go ahead, Melissa. Then you, Max.
I just wanna say that at this point, I know we're not voting technically, but I'm just gonna give my opinion anyway. I feel like this falls under the violation that we already agreed happened, but I really wish, for the sake of this board, that we all have to own our mistakes. And we're all human, we make mistakes, and we need to own them and we need to move on. And I do really, really want IVRIA or the Attorney General's office to come and give us open meeting law training, because clearly we all need it. Because I've been on the board for 2 months and this is like violation number 4 or 5. Like, I don't wanna be doing these meetings, hours and hours of fighting. So that's just my opinion.
Mark?
I think that we just heard what everyone wanted to, I guess, be comfortable moving with. I think we just heard it. I think I heard Chris, you were hoping, I heard Karen say that, hey, if it turns out that these are, then they are. I thought that's what I just heard. If that was the case, then I think we could, as Melissa just suggested, treat this as something that we've already dealt with in terms of that first part. I think if I heard correctly from the other folks, the others we agree that there's no violation that took place. And we find a way to move on from here and see if we can put a period on this and move forward. And that was my recommendation.
Yeah, this one where it's new, but if, I think it's unfortunate that 5 months later, we're here. And people think, like I said last meeting, that I like this stuff. I don't. It's not a good look for us, all of us, all 5 of us. And it wasn't a good look for almost 4 of us for a few months. So I just think it's disappointing when Karen had a response to Dan Dewar's first OML that this wasn't included. That's all, as, by the way, not sure if this is an open meeting law violation, but I did have some exchanges. That's what was disappointing, because the response was unequivocally, I did not speak, which is correct, with Ms. McCarthy. So that's where I'm a little disappointed. And that's it. Well, I'll make mistakes.
And again, going to get Jackie's statement, which is on tape, and we can all review it. She mentioned in the last week, I had conversations with 2 select board members. I am looking at my stuff. I had no conversations, no texts with her in that time frame. She wasn't talking about me. She didn't come forward with this until she was forced to with a PRR. But again, I'm not gonna change my stance. I don't believe these rose to that level. If I'm proven wrong, I can live with that and commit to do better.
This took place back in January and early
Yeah, it
February.
did.
What do you mean?
Can I make a suggestion?
I'm confused.
It feels like you're trying to move forward, yet you keep going back into the mud. I think you need to make.
No, it's not mud. I just said that I'm disappointed. I didn't say I.
But instead of moving the conversation
Yeah,
forward,
well,
it
let's
keeps
move,
rolling
let's
back.
move it forward. Let's move it forward. That's fine.
I guess for me, I just want clarification. Did you communicate with Jackie regarding the town manager selection vote? It's a yes or a no. That's how it is for me. And then I'll vote accordingly on this and anything else in the future. I just have to know, Karen. That's it.
Of course, I made my statements. We've been talking for 20 minutes.
I'm just, Karen, I'm just looking for clarification. We don't wanna
Yeah,
keep
no, I answered
rehashing
that
and
question
going.
already, so
I don't
you
think that
heard
you
it.
did. So, did you?
Point of order, this is badgering, and she did asked and answered.
Oh,
Linda, she didn't answer, so it's.
I just,
I don't agree.
It was a non-answer.
I don't
There
know
was an
how,
answer saying that
I
if
just
this was-
want,
If
Okay,
that's the
all right,
so it's a
opinion
no.
and that's how it's
Let's
viewed,
a no.
then she'll
All right,
own it.
okay, all right.
But she doesn't agree that it is.
Okay,
that's
That's
fine.
what I heard loud and clear, and in
Okay.
fact, folks, you're about to steal absolute defeat from the jaws of victory. Alright, so we can go there if you want, and just keep going,
Okay,
or we can move on. What's it gonna be?
all right, let's work on our response.
To that, I don't vote that this was something that already occurred in the past and it's just tying onto that. This is a completely different incident and
That's not moving forward.
well, not based off your statements. You could very simply say, yes, I did communicate with
Chris, I already
Jackie
answered
over
to
the
that.
town
You're not
manager
listening
vote.
to me. Are you like my husband? Like I answer questions, you don't listen?
I-
Sorry,
I've
Steve,
been-
if you're watching, but she isn't.
I
Folks,
guess I don't,
there's an
I don't
opportunity to
know.
move ahead.
I honestly don't know.
It's an
So
opportunity to move ahead, are we taking it or not?
not without me knowing. I'm being honest. I honestly do not know if it's a yes or a no.
You're trying to
So
get a
it's-
specific answer. What you've heard is that in her opinion, it's no. However, if that's not how it is found to be, then live up to it or own up to it, sorry. And regardless, we all agree that open meeting law training is important and we will engage with it further. That's what was stated. That seemed to be enough, and again, keep pulling back a little bit. So I think that to demand a statement that basically says I abandoned my past position is badgering and asking for too much.
I'm not demanding a statement, Mark. I'm just asking for clarification. I love how it's okay for outbursts to happen all the time. Should we put this in the minutes, Mark? Because I know you were very concerned about the outbursts in the minutes
I
previously.
think that we'll need to go back to a lot of minutes, Chris,
I-
that you probably can remember if we're gonna do that.
I think so. And perhaps text messages that you should reveal as well. I think that.
Point of order?
Yes,
So
it's
here we
okay
are.
for you, Mark, but it's not okay for me.
A point of order, if allowed by the chair,
Yeah.
does interrupt the discussion, right?
Listen, it's 9:30, we still have a few items on our agenda, unfortunately. I am of the stance that, for me, this is new, because it is. And I'm gonna leave it at that. It's new. It's not old. It's new information that I did not have back when it was really bad. Really bad. It would have been helpful. So that's my stance. I'm not saying it's right or wrong. This is new. I am not happy that we're here, but, you know,
You already voted, what was the last bill that you already voted, like you ignored my statement and just voted that I violated open meeting law? Isn't it like all the same thing? You already voted.
Karen, you were a big part of this. Look at the timeline. You can't deny it. You were a big part of this.
I don't think this is about me, Carlo.
Oh, okay. I guess it's about me.
It's about us as a board.
Yeah.
And we're proving that we're incapable of functioning.
Pretty much. Pretty
And that
much.
is why executive session is a good thing. We can do it in private.
We, as a board, provided a statement to the Attorney General that is contradicted in these text messages. That's what we did. We provided the Attorney General with this. Perhaps they're gonna come back and fine us, fine the board, not fine Karen. We provided that. This contradicts our
That is your
response that we
opinion.
gave.
That is your opinion.
That's town council's opinion too.
That, no,
It's-
that was a
it's-
different topic.
She says
That
it's
is-
deliberation.
Whatever. She's like, it's a different topic. My statement is my statement.
Mhm.
And I think I explained, and Mark has reiterated what my statement was, so why isn't that good enough?
Because it's deliberation.
We stated that we committed an open meeting law violation already. What are we looking for?
We're looking for
Carl, I
accountability.
think Ivrea's trying to.
Oh, we're looking for accountability. That's what we're looking for.
I just want to add that 2 members of a public body comprised of 5 members cannot on their own violate the open meeting law. So in my view, it does seem like it is tied, at least in part, to the prior conversations that occurred in order to get to 3. So on its own, those communications are not a violation. It's that when looked at in the bigger picture, potentially, if they are deemed to have crossed the line, they could be part of an open meeting law violation that we've already talked about as part of the Bill Brown complaint.
That's my point.
I'm wondering if as middle ground, the open meeting law response could say something like this. You know, we recognize that between, January 30th and February 4th, various members of the select board communicated outside of an open meeting. We've recently come into new information that potentially additional text messages were sent during this period that was not talked about or disclosed in the past. We recognize this. As a board, we are committing ourselves again to compliance with the open meeting law. We are going to have either town council or the AG's office provide training and sort of just recommit ourselves. So we're not, the response isn't going to say whether or not it's new or not. It's just going to recognize that as a whole, during this time period, violations occurred and we do have new information. We want to correct the record and we all just want to move on. There's a lot of good work that this board does and we're spending a lot of time dealing with this and I want to help and support you however I can, but in general, you do a good job in compliance with the open meeting law. And I think, there was a sticky situation and things are just getting re-litigated a little bit and it's time to kind of respond and move.
No, thank you. I fully support that because, again, this would have been helpful many, many months ago and we could have been past this by now. And so I was accountable, Mark was accountable, even though Mark didn't do anything wrong, but he was accountable for it. Well, not even, he didn't do anything wrong, right?
It's a board violation, right? Like, Mark never intended. He was
Exactly,
very
that's my
cautious,
point.
And we should all follow we talked about this before, ask another board member, can I talk to you about this? There are ways to have these conversations to make sure we're not violating the open meeting law. But you can unknowingly be part of a group that has violated, and that's what occurred with Mark.
I'm okay with what Ivrea said, that's my opinion. I don't know if anyone else wants to chime in.
I agree.
I'm there too.
All right, thank you, Ivrea, for that. You could have said that 20 minutes ago.
She tried to.
She tried to, sorry.
No one
Thank you.
paid attention.
No, that was helpful because we all, listen, there's so much things out there that are unknown that we're never gonna know. But there's things that we know as individuals that we know. Whether they're true or not is a different story. But we all know different things. And we all have our own opinions. So when this came to light, again, I was disappointed, right? I made a mistake, right? But if this came out 3 months ago, I think we'd be in a better place. But it didn't. So let's move on. I'm okay with that response. And I'm just a little jumbled. Do we need a motion? Yeah, we do, right? Yeah. Chris?
I don't even know what I'm, I'd like, so moved with what Andrea said.
Can we do
I
that?
think, yeah, I think you can say, suggested motion would be moved to authorize town council to respond to, the open, I'm sorry, I'm blanking on the filer in this one.
Dewar.
Is this John Lippett? No,
No, Dan Dewar.
Dan. Yeah, Dan Dewar's open meeting law complaint as discussed here tonight.
Second. Oh, no, you can't move it, I'll move it.
Okay.
Second?
Second, Melissa. Any discussion? Seeing none. Melissa?
Yes.
Oh, what's your name? Mark?
Yes.
Chris?
Yes.
Karen?
Yes.
Carlo, yes. Thank you. All right. Discuss rationale for potential select board reorganization, and this ties into the previous discussion we just had. Obviously, I put this on the agenda because I've been very, I guess, frustrated over the past several months. And
Do tell.
yeah, do tell what?
Go ahead, go on.
Yeah, that's why I put it on the agenda. I'm very frustrated that this wasn't brought forward. You had the opportunity in your response, and you chose not to.
Okay, so we're going right back to.
I'm just making a comment, all right? So I'm done. Good, Mark.
So, one of the things that this board needs to do to function again is to literally sit down and talk through how we are gonna work together and what our behavior is going to be, how we're gonna do things, and to make sure that we not only sign a statement that says that, but actually live up to it as well. You and I have been talking about this, I've been asking that we do that and have that discussion for months.
It's coming up.
That's the discussion that should be taking place first, so that we can figure out kind of who we are, how we're gonna do things. If at that point there should be a discussion about reorganizing, that's fine. But to see this ahead of figuring out how we're gonna work together is just wrong. It's just, it smells not of how do we do better, it smells of getting back into the mud. And may or may not get there, but if we can't figure out how to work together as a board, we continue to be dysfunctional, which we are currently, and we gotta get out of that. The reason that I've been pushing this, the reason I even tried to do it a year and change ago, I guess a year and a half ago, although it didn't happen as planned, was kind of for that purpose, so that we can have that opportunity. But if we can't have discussions, if we can't have a set of rules that we're all gonna comply with, then it's very hard to really have a discussion. It's not a discussion. It's one group exerting their will, and that's the way it's gonna be. That's not what the town is looking for. That's not what we're elected to do. We're supposed to be able to set an example, to show how we're gonna do things, and to keep each other doing the right stuff, I guess. And yeah, and occasionally we're gonna misfire. But if we don't have rules, and right now we don't seem to, I don't know how you have the discussions. There's an expression that talks about, how do you have discussions without being disgusting? That's a mission that we need to work on. We're not there. We need to figure out how to do better. I'm disappointed to see this coming ahead of that discussion on how we're gonna work together, because I think until we have that discussion, we're not really a functioning board.
No, I don't disagree, but it's been a circus since February 6th, all right? Melissa should not be right there. All right? She should not be there. It should be Jackie McCarthy. She had 1 year left. All right? So it's been a circus. Prior to that, we were a board of 5. We had our disagreements. We had some ugly meetings. Not that ugly prior to February 6th, but we had disagreements and you know, you and I have had disagreements and well, all of us, right? When Ann Landry was on the board, when, you know, whatever. So this is, to me, a lot different, right? You know, from February 6th, obviously a week before that, but from February 6th to now, it has not been pleasant at all. And I don't disagree with your statements. But when I look at this timeline, it's very one-sided. It's very one-sided and very concerning. I don't know what was said. I don't know. I know what some of the text messages said, obviously, but I don't know what was said in phone conversations. You don't know what I actually said. I don't know what you said, right? But it's been a circus. And unfortunately, I'm the chair for the circus. And you know, we were trying to do stuff. We were trying to have you hold Karen accountable for being late, for being on her phone, and you chose not to.
Wow.
It's true. Is it not
Right
true?
back into the mud.
Yeah. Is it not true?
It is not true.
Oh, it's not true.
It is not
We've
true.
been-
Don't
we've
chime
been-
in. It's
we've
not
been
true. You haven't been
trying to
recognized by the
handle
chair.
things, you weren't
Can
recognized
I
either.
motion to adjourn? This is so
How-
not productive.
How is it not true?
We were trying
Motion
to
to
work,
adjourn.
Okay. Second. There's no discussion. Motion to adjourn. I'll do a roll call vote. Melissa?
Yes.
Yeah. Interesting. Mark?
Yes.
Chris?
no.
Karen?
Yes.
Wow, this is interesting. What was the motion again? To adjourn? Oh, no,
No discussion.
no. All right, we have adjourned.